Ladies and gentlemen, we will now have the panel called Investment Structures and Legal Considerations. So please give a warm welcome to our panelists, Attorney Kristin Charisse, CPA Partner Villaraza and Angangco, Amanda Chen, Partner Foreign Lawyer, Head of International China Practice, RHTLaw Asia, and Yang Eugene, Partner, Co-Head of Corporate and Capital Markets, Head of Education Industry Group, RHTLaw Asia. So this session will be moderated by Attorney Lorybeth Baldrias, CPA, Business Development and Marketing Director, RHTLaw Asia. Over to you, Lori and panelists.
Thank you so much, Imelda. Indeed, we've now come to our final panel for this afternoon, and it's quite interesting to see how the discussion has progressed. And now flowing from the increasingly liberalized Philippine regulatory framework for FDIs, which features new incentives through policy and legislative reforms, as well as the startup ecosystem, it's quite a privilege to learn of perspectives from key regulators and also from important players in the Philippine startup ecosystem. I also note how they've highlighted growth opportunities given attractive valuations in the market, market size and ease in doing business in the Philippines, but of course balanced with the need for proper due diligence and understanding local market nuances. Interesting as well how they've segued into investing into the Philippines through an entity from Singapore, given the relationship between these two jurisdictions. And that is, in fact, a good segue. We'd like to talk more about that here in this third panel, wherein we focus on legal considerations for foreign direct investors and investment structures that can be explored so that we can have maximum efficiencies and gains for foreign direct investors in the Philippines. So as introduced by Imelda, joining me in this panel are Amanda and Eugene from RHTLaw Asia, and Kristin from Villaraza and Angangco, both firms of which are members of the ASEAN Plus group. To start off our discussion, I would like to direct my first question to my dear friend Kristin, who specializes in corporate and M&A and has assisted numerous foreign investors in their entry into the Philippine market. So Kristin, what are the key considerations for foreign investments in the Philippines?
Hi, good afternoon, Lori. I think I will discuss three considerations that are typically asked by foreign clients who wish to invest in the Philippines. First would be foreign investment entry controls. Second would be foreign exchange controls, and third would be investment vehicles available for foreign investors. So first, on foreign investment entry controls, as a general rule, foreigners, whether you're an individual, a corporation, or another entity, foreigners are generally allowed to engage in business in the Philippines, except in certain activities that are partially or fully reserved for Philippine nationals. This may be provided under the Philippine Constitution or under existing laws. So in particular, the extent of equity participation by foreigners in certain businesses or activities is restricted or limited as enumerated in the Foreign Investment Negative List. So this is issued by the President of the Philippines pursuant to our Foreign Investments Act. So the maximum equity interest that can be held by a foreigner in a corporation, in a Philippine corporation, will therefore depend on the type of activity in which the entity will engage in. So just some activities that are currently subject to 40% foreign ownership restriction would be the ownership of land, the generation of renewable energy, operation of public utilities such as distribution and transmission of electricity, or operation of public utility vehicles. Now, for activities that are not expressly subject to foreign equity limitations, but are considered as domestic market enterprises, meaning this is intended for domestic sale in the Philippines, there is just a minimum paid up capitalization requirement of $200,000 US, in order for the enterprise to be more than 40% foreign owned. However, and this is good to note, the amount of required minimum capital may be reduced to half to 100,000 US dollars, which is not really very big if it satisfies any of three conditions. No, first is if it involves advanced technology as determined by the Department of Science and Technology, or as explained in our earlier keynote and panel, if it is endorsed as a startup or a startup enabler by the lead host agencies pursuant to the Innovative Startup Act. And thirdly, if it employs at least 15 Filipinos who constitute a majority of its direct employees. So if you comply with or you satisfy any of these three conditions, then your minimum capitalization requirement is only 100,000 US dollars. And you can be 100% foreign owned as long as you are not engaged in the activities listed in the foreign investments negative list. On the other hand, an enterprise that exports 60% or more of its output is generally not subject to any foreign equity limitation and can be 100% foreign owned. As to foreign exchange controls, well, foreign direct investments may be registered with our central bank, the Bangko Sentral ng Pilipinas, in order to purchase foreign currency from the local banking system for purposes of remittance of dividends and repatriation of capital. This is not mandatory, however, and companies may just source foreign exchange to service dividend payments and capital repatriation internally or from other channels. As to corporate vehicles available, so there are a few, but I'd like to just focus on two common forms which are used by foreign investors doing business in the Philippines, and these are a domestic Philippine corporation and a branch office. So a Philippine corporation may either be an ordinary stock corporation, or it can also be a one-person corporation. Under the Philippines, a corporation is a juridical entity with a separate and distinct personality from its shareholders. So where a domestic subsidiary of a foreign corporation is created, there will be two separate and distinct corporate entities. And so the Philippines subsidiary is a legally and independent unit as a domestic corporation. On the other hand, a branch office is considered merely an extension of the parent or the head office of the company. So there is no independent juridical entity created by the establishment of a branch office. So for example, any judgment or claim or liability against the branch office in the Philippines is a liability of the head office or the foreign corporation. So assets of both branch office and foreign corporation may be charged with liability of the branch office. So because of the limitation on liability of the parent company in a Philippine corporation, we consider this as the more preferred option compared to establishing a branch office of a foreign corporation.
Thank you for sharing those, Christine. Yes, there are a number of corporate vehicles indeed that can be used to enter the Philippine market. And it's also quite interesting how you've mentioned about foreign investment entry controls. And I just want to link that with what has been shared in the first panel, wherein our regulators have shared about the relaxation of foreign direct investment rules, given the passage of the Public Service Act and amendments rather to the Public Service Act, Foreign Direct Investments Act, and the Retail Trade Liberalization Act as well. So just given those, could you also share more about challenges that foreign direct investors may encounter from a legal perspective, and also some other structuring considerations to help address those challenges, such as perhaps structuring that holding company from a foreign jurisdiction, such as Singapore?
Sure, Lorybeth. Well, there are several factors to consider in structuring foreign investments in the Philippines, and this would include commercial objectives of the investor. So there is really no one-size-fits-all solution. But in the fast-paced tech sector, for example, a major consideration is the ease in implementing share transfers. So how new investors can buy shares, how existing investors can exit, how capital can be restructured, those things. Unfortunately, the tax and regulatory regime in the Philippines is, let's say, less than ideal for share transfers. So each share transfer is subject to payment of capital gains tax or donor's tax and documentary stamp tax. So after payment of these taxes, a certificate authorizing registration must be secured from our tax authority, which process can take around a month or two. So this creates a gap from the time the shares are sold until the buyer can actually be recorded in the books of the corporation. So with the holding company structure in a different jurisdiction, which does not impose taxes or require consent for share transfers, buying and selling of shares and capital restructuring can be done at the holding company level, and the regulatory requirements in the Philippines can be avoided. Another significant factor would be tax efficiency on payment of dividends by the Philippine corporation to the foreign shareholder. So dividends paid by a domestic corporation to a non-resident foreign corporation is generally subject to a final withholding tax at the rate of 25%. This rate can be reduced to 15% following the tax sparing rule under certain conditions. So if the country in which the foreign shareholder is domiciled either does not impose tax on such dividends or allows a tax credit for taxes deemed paid in the Philippines equivalent to 15% of the dividends. Also, reduced rates may also be available under relevant tax treaties. So tax savings of at least 10% of the dividends may be enjoyed if a holding company is established in a jurisdiction where reduced rates would be applicable. So considering these two reasons, the ease in share transfers and tax efficiency in payment of dividends, and just assuming that there are no other compelling factors to consider, it is actually generally preferable to have a holding company layer in between the Philippine company and the foreign investors.
Thank you, Christine. Those are indeed very important considerations for investors who may want to eventually enter, exit a startup or any investment that they may have, or change their investment structures accordingly. And as I think we may well know, sometimes securing that certificate authorizing registration from the Bureau of Internal Revenue may even take several months, or sometimes a period of a year. And but of course, there are ways to go around with that, and hence the holding company structure as a solution in a tax jurisdiction which has reciprocity, and also which has a solid and reliable double tax avoidance agreement framework. It is very helpful to note. So at this point, I'd also like to explore further, this time around from the perspective of the foreign direct investor, specifically from the perspective of FDIs from Singapore and even from a third-party jurisdiction, such as, say, for example, China, which has a lot of interest in investing in the Philippines or entering in the Philippine market. For this, I would like to turn to my colleague, Amanda, who's a dual qualified lawyer in Singapore and China, and who specializes in FDIs, M&As, and joint ventures. So Amanda, as head of RHT's international China practice, you would have had experiences with mainland China clients who want to invest in the Philippines. I just wonder, do you see a number of these Chinese FDIs investing through jurisdictions such as Singapore? Could you provide some examples on that note?
Yeah, thank you, Laurie. Hello, everyone. Okay, actually for PRC investors to invest into Philippine or other ASEAN countries, I think the first question to ask is that whether they are familiar with that destination country in terms of culture, language, and then whether they have any partners there, right? And if they don't, then it's very difficult for them to go into a market where they are not familiar and they don't have anyone to handhold them. So under such scenario, then very likely that they might want to consider looking for a country nearby where they might be relatively familiar. So based on my experience, because I've been working in Singapore for about 20 years, so I mean, PRC clients, when they come to ASEAN countries, I mean, the favorite country to land first is actually Singapore. Yeah, and there are a lot of precedents and examples there. And like anyway, there are a lot of big tech companies landing in Singapore and other industries as well. Yeah, and there are listcos from China or headquartered with China, but listed somewhere else like NASDAQ, etc. Yeah.
I see. Thank you, Amanda. And since, to be specific, what are the advantage of, say, landing in Singapore first over other jurisdictions? Because there are also other jurisdictions which are nearby in terms of setting up a holdco structure.
Yeah, I think yeah, Singapore stands a very, very good advantages. I think first of all is actually cultural similarity and geography proximity. I think actually when I first came to Singapore, I was offered a job here, and at that time I was actually in Sydney. I was planning to stay in Sydney permanently because I got a PR there, but I couldn't feel belonging to that country and that society, and hence I came to Singapore, and because of the language, culture, you feel belonging to this country even when you first land in Singapore. So I think a lot of Chinese people may feel the same as me. And also geography-wise, just maybe 4 to 5 hours, you can land in here. And so it's very, very convenient for PRC investors to just travel to Singapore and then maybe go back to China. And secondly, of course, because of the transparent legal system and legal enforcement here, which will provide a lot of certainty to the commercial operation here. You'll be very surprised to see that during pandemic, I actually have received some queries from PRC clients where they are actually intending to set up a manufacturing base in Singapore. So the first question that I asked them is that, why you choose Singapore? Singapore is so small and the land is so expensive. Can you afford? And then the answer is actually, especially during pandemic, there are a lot of uncertainties, a lot of countries, and maybe because it's unprecedented. So they were actually thinking of Malaysia, but when they compare Malaysia against Singapore, they are convinced by Singapore's transparent legal system and a lot of certainties that they can be assured. And while in Malaysia, there are a lot of uncertainties, so they would rather spend a bit more and to land in Singapore. So that's why, I mean, the legal system here provides very, to a large extent, assurance to the business operations to operate here. And another point, of course, because in China, under PRC legal system, there is foreign investment entry control, as well as foreign exchange control. So for PRC investors, when they venture out offshore, the very first question they will ask that, oh, okay, in your country, is there any foreign investment entry control enter this line? And or do you have any foreign exchange control, like in China? Any money in or out has to be strictly monitored by the relevant authority. So while in Singapore, I think it's very clear that there is no stringent foreign investment entry control, and to set up a company is so straightforward. Of course, subject to a lot of background check and AML CFT, but it's relatively straightforward. Of course, foreign exchange control, there's none here, and it's so much easier for business to start here in Singapore. Another point, I think, in terms of tax system, Singapore's tax is, as compared to China, because China tax system is very complicated. While in Singapore, there's no capital gain tax and 17% income tax, and there are some tax incentives in like financial sectors and other sectors. And also for personal income tax, individual income tax is also relatively lower as compared to China. So tax efficiency, I think, will be another factor. As to others, of course, like financial markets. I think in Singapore, the capital market may not be that attractive, because all along people like to compare Singapore against Hong Kong. But I think in the recent years, due to the international geopolitical reasons, I think more and more PRC clients and investors would prefer to move the assets and business to Singapore as compared to Hong Kong. And last but not the least, I think Singapore also provides a very good talent pool. In here, you can find, you can recruit as many as possible those talents from different lines, yeah, and either local or they are actually from other countries. Yeah.
Thank you for sharing that, Amanda. And I could actually, on a personal level, resonate as well with what you shared about feeling at home. I think we both can relate to that as foreigners who have moved to Singapore. And interesting how you have also pointed out the comparison between Singapore and Hong Kong. I mean, not to disparage Hong Kong, but that is actually a question that Filipino lawyers who are into structuring FDIs and M&As get. The question would be, where would it be best to set up a holdco structure? Would it be in Singapore and Hong Kong, or Hong Kong? And I think our webinar this afternoon, this panel in particular, responds to such question. Notable how the tax system in Singapore is likewise very straightforward. You mentioned about how the tax system in China can be a little complicated, and I can resonate with that as well with respect to the Philippine tax system, as well as
for Philippine one.
Yeah.
Actually, I wanted to share that just now Kristin mentioned about the share transfer can be
Yes.
quite painful in Philippines. And I did have disco clients from China. They came to us with an assignment that they have a subsidiary in Singapore, which in turn holds the entire shares in a Philippine company. Well, because of some share transfer about many years ago, I think really more than 4 to 5 years ago, and it was not done yet. So
Oh
they
my
were
gosh.
so frustrated, and they are a SOE,
Oh.
state-owned company. So and they were actually, before they came to us, they actually have engaged one of the big fours to try to liaise with the your tax authority, but couldn't figure out. And so they had to really look for legal counsels to help to settle this. Yeah, we participated in the pitching, although we didn't get it in the end. But I mean, from that experience, I mean, I was very surprised to see that, wow, it's so tedious and complicated. So I think it's very important to engage reliable legal counsel in Philippines at the very beginning to guide and to make it smooth.
Kristin and I are nodding our heads profusely because we've had a lot of war stories along those lines, and especially perhaps Kristin, when you try to apply for a preferential treaty rate or a tax exemption, even for exemption from capital gains taxes, it all the more prolongs the process, right? Have you had some experiences on those as well?
Yeah, that's right. And some clients would actually just forgo the tax exemption and just pay the tax just to shorten the process.
So I think the structuring from the onset, from the get-go, is quite important. Whenever you enter the market, it is important to pre-plan these things. Yeah. And so thank you for that, Amanda. I think it sparked some robust discussion here. And now that we have established that Singapore appears to be a preferred jurisdiction for holding company structures of investee companies in the Philippines, I would now like to direct the following question to my colleague Eugene, our colleague Amanda, who co-leads RHTLaw's corporate and capital markets practice. And he likewise has extensive experience in private equity, mergers and acquisitions, joint ventures, among other things. So Eugene, based on your experience in structuring corporate structures, holding company structures, what are the types of holdco structures that FDIs can make use of in Singapore?
Yes, good afternoon, everyone. Thank you, Lorybeth, for introducing, the topic. I think the discussion so far and throughout this entire seminar has been, very informative in terms of what can be done inside the Philippines. And I think it also has been established that Singapore is a preferred jurisdiction, certainly one of the preferred jurisdictions for FDI to go into the Philippines. So I suppose it would be good to anchor the discussion, to close the loop, the last sort of piece in the chain, to know a bit about what are the structures that are available in Singapore in order for people to invest in overseas jurisdictions, including, of course, the Philippines. And I just want to, run through quickly what are these available structures, and all of which actually have been used before, of course, with varying degrees of popularity. The most common one, of course, is simply a private limited company, or some people who are more used to an American nomenclature, they will call it a limited liability company, an LLC. It's referring to the same thing, and this is basically your standard limited liability private company, which you can set up very easily in Singapore, and it will issue shares, and you have shareholders and a board of directors, and that entity is in fact the most common entity used both domestically as well as for investing overseas. in terms of entities set up in Singapore. So it's relatively cheap. It is easy to set up. And in terms of compliance requirements, fairly minimal. I mean, you do need a resident director in Singapore, but quite often these things can be arranged as well for investors or shareholders who are entirely based overseas. There is no requirement for local shareholding. And I think that is different from many jurisdictions, certainly in Asia. So it can be wholly foreign owned. That's not an issue at all. It's cheap and easy to set up. But in a way, it is quite, I mean, this structure has been around for a very, very long time. And it is quite similar to, of course, we've imported our corporate law from the UK and from Australia and all that. It's the same kind of private limited company. So whilst it is tried and tested, it works most ways. It of course comes with certain limitations as well. So for example, you can't, capital maintenance rules are in place, quite strict. Of course, over the years, the Companies Act has been liberalized to, create a lot of exceptions, but nevertheless, you can't just take money out of a company, right? So it has to go up legitimately, quite often in the form of dividends, right? If the company makes profits, you can dividend the profits up, to shareholders. But what if the company does not make profits? So here you have a question. It's, the money could get stuck in the company. It could be cash rich, but it's actually not making money. And then the company could be stuck. Of course, there could be ways of dealing with this, such as a capital reduction, for example. That's not often so easy to do, and there's certain requirements which some directors are a bit wary of going down that line because they have to sign certain personal statements about the company's solvency. So it's tried and tested. It is, in most cases, still the preferred go-to vehicle to be used. But there are other structures as well. Another, of course, very old, English-based structure is also just a partnership. So it's quite rarely used because I think most people like the idea of having separate limited liability between the shareholders and the company. That's why a company is used. But I've encountered instances where, they don't actually want to use a company, they just want to use a regular partnership. They don't want a corporate structure. They don't want the reporting requirements. They don't want to have to, file accounts and things like that. So they just want to go with a very simple structure. And usually there aren't too many partners involved. So they just go with a general partnership structure. But that is has its dangers and drawbacks because, as I said earlier, it's not a separate legal entity. So there's no shield in terms of liability. The partners are all liable for the debts that are incurred. And also, so you have a partnership, say, of 3 partners, each holding 1/3. It's not that each partner is liable for only 1/3 of the liability. Each of the partners are liable for the entire liability of the partnership. So that also creates quite a discomfort. So I have to say this is a structure that is rarely used, although I've had a couple of clients, actually not many, who insist on using it because of, I guess, it's simple. It's very simple. But what is quite often used actually by investment funds, right, is actually this vehicle called limited partnership. And I think for people who are, used to setting up investment vehicles, quite often offshore, and people generally operate in the fund space, you would have heard of this idea of an LP. And in fact, a lot of Western investors, they come to you and say, oh, I want to set up an LP, because that's a structure they know very well. Well, an LP, as the name suggests, allows for limited partners to come in to this partnership as well. So it has to have at least one or more general partners, which are, as the name suggests, liable for everything. But it also allows limited partners to come into the partnership. And these limited partners, usually they are financial investors. They're not the people actually running the investment fund. They are just investors in the fund. They have limited liability. So it provides a shield for them such that, the worst that can happen is they lose their capital that they've invested. But at least, they're not liable for the debts of the partnership in general. So that GPLP structure is quite often used for investment funds investing, both domestically, but quite often used to invest overseas in the region, including into the Philippines as well. And the next structure, this one is quite often used, for example, by professional partnerships, and in fact, others use it as well as an investment vehicle, because it is, for all intents and purposes, even though the name says limited liability partnership, is actually a separate company. It's a separate entity with its own separate legal personality, and as I think the term that they use in the Philippines is a separate jurisdictional personality, right? I hope I named that correctly. So, so it actually provides limited liability for the people who put in capital. The benefit of this structure is that as far as taxation is concerned, it is tax transparent. So it is taxed entirely at the income tax rate of the individual partners. So there's no corporate tax. So, but for all intents and purposes, it actually functions very much like a company, and it provides limited liability. So this is also quite a popular structure. Certainly in Singapore, the limited partnership and the limited liability partnership are fairly new structures. They've only come about, in the past decade or so. Before that, certainly in the past century, you only had a private limited company, an LLC, or a general partnership. But with the creation of limited partnerships and LLPs, it allowed for more investment vehicles to be used for investing both domestically and overseas. But actually, in my view, the most exciting one, so I've sort of saved the best for last, is the creation of this legal creature called a variable capital company, a VCC. And the VCC is structured very much and drew a lot of inspiration clearly from an SPC that you'll find in jurisdictions such as the Cayman Islands. And a lot of funds are actually set up that way using an SPC, right? And as the name suggests, SPC stands for Segregated Portfolio Company. The beauty of this structure is it allows within one legal entity separate cells of, shall I say, sub-funds, although I use that term quite carefully, because certainly in the case of a VCC, these sub-funds are not separate legal entities in themselves, but nevertheless, it allows for each sub-fund to be segregated in terms of assets and liabilities. So I think that then allows for a very versatile structure, in the sense that the VCC can have many sub-funds, and investors investing into the VCC can also invest specifically in the sub-funds that they want to do so in. And there is no limitation in terms of a theme. So a VCC can be, and this is what we call an umbrella VCC. It can actually do pretty much everything that you say that it can do in its constitution, and of course in the sort of the investment memorandums that you give out to investors. So it's only limited what you say is limited by, in terms of things that they can invest in. So it can be, in a way, it covers all manners of sins, as we say. You can use that one vehicle to invest in a whole variety of different underlying investments, and you can invite investors to come in. Usually the share structure is again, there'll be management shares that the promoters will hold, and that usually gives them control over the entity. But then you also can issue participating shares to investors, which perhaps, for example, may not carry with it voting rights, but it gives them, of course, all the economic benefits. And you can, if issue different classes of these participating shares, each one investing into a particular sub-fund that in itself invests into an underlying investment. And it can be in a different jurisdiction, it can even be in a different industry. But that said, I have to say that, and we have set up quite a few of these in the last 2 years, 2.5 years alone since the regime came into force. Usually there will be some kind of a theme, because otherwise it just appears too schizophrenic. And if a promoter or fund manager goes out there and says, I've got an umbrella VCC that can do everything under the sun, investors might get a bit worried. Not because they're worried about their own investment, which should have very clear underlying, theme or assets, but they're saying, then what do you specialize in, Mr. Fund Manager? I mean, you seem to cover everything. So usually they don't do that. Usually they would say, okay, there's an underlying theme, but for example, each sub-fund could vary by geography. So it could be a tech fund, for example, or some kind of a healthcare fund or something. There will be a theme, but it could invest, for example, in different entities in different jurisdictions. Sometimes the entire umbrella VCC could be in just one jurisdiction, and they use each sub-fund just to invest in one underlying asset, for example. Just to make it very clear and very focused in terms of what that sub-fund is going to do. So it's very easy to make out an investment case. When you draw up your supplemental PPM or IM, you show the investor, this is the asset, these are the prospects. Do you want to invest in this asset or not? And the beauty, because of the ability for investors to then each invest in a specific sub-fund, the investors themselves can mix and match. And we have seen many situations like that, because, for example, the investor is $1 million. He doesn't have to put all $1 million into sub-fund A and just subscribe for Class A shares. He can say, okay, I'll allocate maybe 30% to sub-fund A, 40% to sub-fund B, 30% to sub-fund C, something like that. So they can choose to mix and match and blend their own investments, all going through the same legal vehicle, but all going into different underlying sub-funds. And because the liability is segregated, if one of them, somehow the investment goes south, at least the other two are unaffected. And you can actually just wind up one particular sub-fund. You don't have to say wind up the whole VCC. So I think it is a very, very versatile structure that I have to say the regime started at the beginning of 2020. Took a little bit of at least 6 months or so for people to actually just cotton on to the fact that there's such a vehicle. But once I think it sort of sunk in terms of awareness, it kind of just took off, because people could see the versatility of using such a vehicle. And if that isn't good enough, actually one of the benefits of a VCC as well, and which again, as compared to, for example, a private limited company, which I mentioned earlier in terms of capital maintenance, is much more structured, and there are stricter rules. A VCC is not restricted to upstreaming distributions from dividends only. So you can upstream from capital, for example. So it's a lot more flexible. The sub-fund need not necessarily be making accounting profits, and you can upstream, returns to investors. So that makes it, to some extent, like a partnership, like a unit trust, in terms of other structures. It makes it very versatile in terms of giving returns to your investors. You are much more flexible in terms of, returning gains that you make from underlying investments to investors as well. A VCC is taxed like a company, so it's subject to the standard corporate tax rate, which in Singapore is 17%. So that's tax-wise, as far as the corporate tax rate, it is the same as a private limited company. But again, in Singapore, there's one-tier tax, right? So you just tax at the corporate rate. It's not, again, taxed in the hands of shareholders of either participating shares or of the management shares. So I would say that we are quite excited, and we are seeing the growth of the use of this vehicle as an investment tool for FDI into other jurisdictions. And in fact, quite often that is the case. They will invest in underlying investments all over Southeast Asia, and certainly I think The Philippines is no exception to that. So I think that's a quite a quick overview. Oh, it's taken a bit longer than expected, but it is of the different kinds of structures you can consider using in Singapore to invest in the investments, certainly in the Philippines.
Thank you for that very comprehensive discussion, Eugene. And it's quite interesting, the concept of VCC. I mean, it seems like the best of both worlds. You have features of a normal private limited company, a corporation, and yet also features of a partnership with a separate cells of sub funds. It's more like an accounting concept, right? And seems like it's the perfect vehicle for an investor who would like to diversify his portfolio.
I would like to
Yeah.
share also
Mm.
that on VCC.
Mm-mm.
I think for PRC clients, because all along, when PRC clients set up the so-called offshore USD fund,
Mm-mm.
their preferred jurisdiction is always in Cayman because of course, their legal system is quite developed in terms of fund and fund management. They have SPC, right? And I think our Singapore's VCC very much transplant a lot of features from SPC. And on top of that, I think we still have our own features. And hence, when PRC clients are aware of this new system and new so-called law and legal structure, they are very keen to actually explore here. And we do have clients that after they obtain the fund management license, when they actually have some fund in Cayman and Hong Kong, they are very much keen to actually set up a VCC in Singapore. Because before that, because of the legal system, as in the regulations, they prefer to go to Cayman. But now with the VCC Act here, then they don't mind actually exploring setting up fund on top of the fund management company in Singapore as well. Yeah.
Yeah, I have to. Okay, I mean, the world is not perfect. I mean, it's not that. There's only one, I have to say, slight drawback, and that is it's a bit more expensive. So, I mean, just to set it up, I mean, for example, a normal company, it's almost
well,
free.
but now they have as in
their government subsidies.
The government
actually,
subsidy,
correct,
right, is
yes.
quite generous.
Effective.
Actually.
Yeah, that's true.
150K.
But it's looking like
So,
it might expire next year. So
yeah, that's why people are rushing
if you want
to
set up this year,
Yeah. Do you have the number of VCC set up in Singapore? Eugene, do you have the statistics?
Well, I would say I won't be surprised at all if by now it's certainly into the very, very high hundreds.
I thought it exceed 1,000 already. I
would think so.
Yep.
I would think so because last
Yep.
I checked already it was well into the hundreds.
Yeah.
So but so there's that, and it does because it's regulated by the MAS, or the MAS has some oversight. So they actually require a licensed fund manager to manage the VCC. So you either have to have a fund management license or you work with one. Of course, there are many people out here who do offer that service as well. So it does need to be in a way professionally managed because of all these benefits, right? They don't want people, just a man on the street to do it, and then whole thing gets mismanaged, and investment gets lost. So they want to be professionally managed by a fund manager. So that's
and I think there are certain tax exemptions applied to VCC as well.
Yes, no, I would say, in fact, sorry, I missed out one beauty of a VCC as well, is that it can actually tap the entire tax treaty network that Singapore.
I think ONU, yeah.
That's right, which a normal company doesn't have that advantage. So a VCC is incorporated into the VCC Act, that all your double tax treaties that Singapore is a treaty party to, the VCC can avail itself to that. So when it comes to, and many times that's exactly one of the main reasons why they use the vehicle, because in terms of royalties, in terms of all kinds of distributions outside, going back to their home country, otherwise you'll be subject to withholding tax and all that sort of stuff. So the ability to access the tax treaty network of Singapore is again one of the strong incentives that I think has pushed people to use the vehicle. So usually, often I think investors or promoters, they do the sums and they realize that a bit more they have to spend on setting it up and maintaining the VCC is offset by the tax savings they have when they can access the double tax treaty network, especially for investors from overseas or promoters from overseas. I think it more than covers the extra cost.
Yeah. Never mind the extra cost indeed, for as long as, the tax savings, the regulatory structures that are in place by having an MAS licensed fund manager. Looks like the VCC has made Singapore as an even more attractive jurisdiction for holding company and fund structures. And given the limited time period for the incentives, looks like the best time to invest in VCCs is now, right? Yeah. So these are certainly very helpful pieces of information that can help foreign direct investors decide on how to move forward quickly at that. So at this point in time, would our panelists have any final words or points that you would like to further highlight concerning legal and structuring matters for FDIs in the Philippines from and through Singapore? I'd like to first ask Kristin. Yeah.
Okay. Well, I'd like to echo what has been discussed by the keynotes and across the different panels this afternoon. The Philippines is really ready to, welcome foreign investors. We've substantially liberalized our laws. We've relaxed foreign ownership restrictions. We've lowered investment hurdles in very exciting sectors such as retail, telecoms, logistics, infrastructure like railways, subways, expressways, and tollways, and there are also very great incentives for startups in the Philippines. So while these barriers to entry have been removed, the regulatory environment is still, very much complex. And as in any investment anywhere in the world, it really does pay to, do your due diligence. And as you mentioned, Lori, to structure your investment from the get-go, from the beginning, to consider all these factors and to make sure that it's not just for now, but for the long term. So that's it. And we hope that there are more foreign investors who would consider the Philippines, and we'd be happy also to help investors structure their investments in the Philippines. Thank you very much.
Thank you, Kristin. Amanda?
I think under the current international geopolitical environment, Singapore really stands an incomparable strategic advantage for the PRC investors to venture into ASEAN countries in like Philippines. So we look forward to assisting more PRC clients here to establish their international headquarters in Singapore and further expand their footprint to other ASEAN countries like Philippines. Thank you.
Thank you. And Eugene?
Yeah, well, I think structuring is important, right? I think, anyone thinking of going into the Philippines, even if, say, using Singapore as a base, still one has to consider what is most suitable and optimal in terms of how you go into the Philippines. So I think, do also think about possibly using an intermediate holding structure somewhere, such that it is efficient when it goes into the Philippines, and the local vehicle used in Singapore can then, just go into the intermediate holding structure first, and then go into the Philippines if necessary. Of course, you got to look at, you also don't want to overlay it, and then if the taxes all the way around, that's also not efficient. So it has to be a tax efficient structure. But I think that is a possibility that you need to get around certain things. think of using an intermediate structure as well. Yeah.
Thank you, Eugene. And at this point, also let me end by saying that we at RHTLaw, VNA, and our ASEAN Plus group would be very happy to assist FDIs into the Philippines from a legal perspective, especially those that are going to invest through and from Singapore, and also even outbound FDIs from the Philippines that would like to invest into the ASEAN region and use Singapore as a hub. And this wraps up our final panel for this afternoon. Over to you, Imelda.
Thank you very much, Laurie and panelists, for sharing your insights, and it's really very comprehensive.